I think what we got there was a glimpse of just how far the police would go, if they were given unrestricted powers to hassle all the rest of us. They would get stuck into ordering us around for no particularly good reason, just because they thought that was helpful for some reason or other. They wouldn't be restrained, and they wouldn't be thinking only of doing whatever was reasonable to try and achieve a particular objective. They'd just be very bossy and very
No, I agree.
I haven't got a good word for it really, but but it is alarming to see just how far they will stray from even these enormously enhanced powers that they've been granted as a result of the coronavirus emergency legislation rules.
And it affects so many these regulations, rules, this law affects so many different things, and things that have got absolutely nothing to do with the virus. So there's a couple of things I'll go back to, and then I'll bring up your letter. We can talk through that, and there's a couple of things that I wanted to show on the screen. But what is really important, especially if not just to be, I've always said to people, the English Bill of Rights and Constitution is the beating heart of the American Bill of Rights and Constitution, because it largely comes from us. So, what is the comparison?
It's the case that some of those who were in the American Constitutional Convention, as it were saying that what they wanted was the rights of a freeborn Englishman.
And I totally agree with that. So there was without going into too much detail, can we give a comparison of, for example, the Declaration of Independence and the Constitution in reference to the process in England? What caused the Bill of Rights?
So, in terms of looking at the development of law in England, you've got to think. I'm afraid you've got to go right back to the Dark Ages, but we won't spend too much time there. Basically, in England, the English came into what had been part of the Roman Empire, the province of Britain, and they completely overrode everything that had existed before. Not only in law and in culture, but even in terms of how they dealt with the towns and the buildings and so on. They didn't occupy the old Roman towns. They didn't even use the Roman roads. The roads were used as demarcation points rather than as something to travel along. And they set up. They had a completely different idea about their relationship with their chiefs or kings, so that they weren't interested in having a setup where the king had the right to make law himself. I mean, Justinian's Roman law code digest says that the supreme law is the emperor's will. Right? So Roman law, as handed down across Europe, is the law of tyranny. I think just to show how much of a tyranny, when Justinian, when so-called senators came into the presence of Justinian, they were required to prostrate themselves on the ground with their face into the ground, unless Justinian permitted them to look up to speak to him. So he was an absolute tyrant, and that's the kind of law that has come down from Rome to us or to European countries. That's the sort of basic position that the state, to put it in modern terms, the state grants rights. You don't have any natural rights. Whereas in England, the English thought that you had natural rights, and that the traditions of the English people were the basis of law, and that the king really only had the right to say, well, you can't do that, or that. So the king only had a few sort of points where he could issue orders removing the wider rights, and usually for good reason only. That developed with King Alfred, who published a legal code, and it was well established. Basically, the concept of having an assembly, the Witan, which is roughly our parliament, the monarchy, and obviously the king had judges as well. So quite a lot of the elements of what we would think of as the constitution had already come into existence before the Norman Conquest. And then, of course, after the Norman Conquest, we get some post-Norman Conquest kings behaving very tyrannically. In fact, I think probably fair to say most of them did. But eventually, the people and barons even had enough, and under King John, they started the process of trying to create a constitution. And it's worth remembering it was actually the first attempt to try to say that the king was subject to law, the same as everybody else.
Interesting. The first time that it was being said that the king was subject to law, and that was interesting point about the Roman or Norman, the Conqueror, William the Conqueror.
The law that applied to him wasn't exactly the same. So he had powers that ordinary citizens wouldn't have, but nevertheless he was somebody who was subject to law. And as it happened, in the way that politics developed, his son, Henry III, it was necessary for Magna Carta to become a sort of manifesto for a more moderate, responsive and controlled monarchy. And one of the key people that should be remembered in that process is William Marshall, who was the key sort of saviour of the English monarchy at that point, and was the person who made sure that Magna Carta became embedded in our constitution. Moving forward a long time to the 1689, 1688 Boris Revolution. Some people want to say invasion, because of course it is true that some 10,000 Dutch soldiers came over with King William, or Prince William at that point. But nevertheless, what he was invited over by many key people. The English army didn't fight him. In fact, went over to him in a large extent. And the pre-existing king, James II, gave up and fled the country. So you've got a situation where there's no functioning monarchy, and therefore Parliament technically couldn't be called by the monarch. We'd obviously not had a functioning monarchy during the during the Protectorate and interregnum, so-called, during the Commonwealth period after the Civil War, so it wasn't a completely unknown situation in England at that point. But what was unusual about the 1689 convention is that it came up with a declaration which fits quite neatly with the Declaration of Independence and also the drafting of the Constitution, because you can see there is a process there. The convention comes up with a declaration of rights. next stage is that the King and Queen agree to that formally. And once they've agreed to that, it's then turned into an Act of Parliament and embedded in our Constitution as the Bill of Rights, 1689. And so that really is our key overarching constitutional moment. And I think the big question that needs to be answered, and I think that all these coronavirus emergency powers may be a good point at which to get it answered, is whether we actually do have the sort of constitution that provides any checks on what ministers can do. Because obviously if we haven't, we then don't really live in a country ruled by law at all. Particularly when you bear in mind that the judges are appointed under a system set up by Tony Blair's government, and not the historic constitutional way of appointing judges. Instead, they're appointed out by the Judicial Appointments Commission, which says that you can't even really begin the process of applying to be a judge unless you can demonstrate a lifetime's commitment to equality and diversity. And in this country, if you say equality and diversity, you are using the official jargon for multiculturalism. So in other words, unless you're a multiculturalist, you can't become a judge. And we saw that in the case we tried to bring home in Article 50. We wound up with a fairly extreme example, I would say. One of the judges looked at it, or Justice Heath, turned out to be a judge who had signed up as a fellow of the European Legal Institute. And the European Legal Institute, in turn, when we looked at it, is an institute which has as its purpose that the fellows should act behind the scenes to deepen, further extend and entrench EU law. So, in other words, the guy was an activist for the pro-EU cause, yet he's sitting on and deciding on our case.
And again, this goes back to this ideology, whatever it is in the background that's controlling it. This is not about technically invasion, it's about infiltration. And you can see, if you piece it together, how they have gradually chipped away at the Constitution. I mean, from early 1970s, removing it from the bar exams, removing it from the curriculum in schools. So they honestly believe that, and bearing in mind, I'm going to get onto it in a second, that the Bill of Rights clearly states on 3 occasions that the Bill of Rights is forever. And on one occasion, in its construction, it says that it's not just forever. It is the most solemn bill, right? So I'll go into that. But there's a couple of other, just a quick thing to say to this is, whether it be Parliament, whether it be the executive, and I completely agree that, literally, the Americans probably wouldn't understand what's going on here, but it's almost like taking a presidency, and bearing in mind George Washington, they asked him, do you want to be the king? And he said, well, I want to be a king, I'll be the president. But it's like taking that position and then putting it and the administration within Congress and the Senate. So in other words, there is no presidency, there is no monarchy, so you've lost one of them things. But the point I'm going to make is that when we have rights that are given to us by God, that's what the English have always believed, and especially all the way back to King Alfred when he brought England together as one nation under God.
King Alfred, one nation under God. So also it's very important to understand what our God-given common law, man on the land rights are.